Good morning. My name's Herb Thiele. I'm the county attorney here in Leon County, the Leon County's first in-house lawyer, and they apparently can't get rid of me that easily, so I've been here 23 years now. Just to get you started off on the right foot, this is a letter that was sent to the principal's office in Keene Elementary in Wooster, Ohio. The letter was sent after the school had sponsored a luncheon for the elderly. An elderly lady who had gone there received a new radio at the lunch as a door prize and was writing to say thank you. It starts out, "Dear Keene Elementary, God bless you for the beautiful radio I won at your recent senior citizens luncheon. I am 84 years old and live at the Springer Home for the Aged. All my family has passed away. I'm all alone now, and it's nice to know that someone is thinking of me. God bless you for your kindness to an old forgotten lady. My roommate is 95 and has always had her own radio. But before I received one, she would never let me listen to hers, even when she was napping. The other day, her radio fell off the nightstand and broke into a lot of pieces. It was awful, and she was in tears. Her distress over the broken radio touched me, and I knew this was God's way of answering my prayers. She asked if she could listen to mine, and I told her to kiss my ass. Thank you for that opportunity. Sincerely, Agnes Baker." That's the kind of humor that I normally have, so that's why the Trouble with Tribbles slide was the one that we chose to start out just as a concept here. My job here is really threefold. One, I'm the warm-up act to the other presenters for the rest of the day, including the Ethics Commission and Pat Gleason from the Attorney General's office, who will really hit more on the details and the substantive issues. My job is to kind of give you an overall of areas of concern that you ought to at least have in the back of your mind as potential problems for you if you're not careful. And so we won't do much detail, but I do want to hit on a couple of things and show you examples of how when things go bad, they actually can go bad in a hurry. So it will be a whole smorgasbord of different issues that we're going to talk about this morning. First off, land use in the last 5 or 6 years in your counties, because every county has virtually been the same, has been at a very low ebb. We haven't had a controversial land use project come to the Board of County Commissioners since maybe about the year 2004, and that lull is about to end. There's way too many properties that have been purchased in the last 5 or 6 years due to foreclosures. A lot of bad properties that probably would not have been developed have now been purchased. And so you're going to see coming across your desk applications for site plan approvals or rezonings or plats that you probably might not have seen in your tenure on the commission, and certainly your peers on the commission haven't seen anything like it in half a decade or so. So a lot of people have forgotten that in 1993, the Florida Supreme Court changed all the rules that are related to land use decision making for local governments, including you. And specifically, what used to be a legislative process has turned into a quasi-judicial process. No, that doesn't mean you get to wear a robe when you enter the commission chambers, unless, of course, you pilfered one from the Hilton in Destin when we were there a couple of months ago. But you can act judicially. And no one expects you to be a judge. No one expects you to be a lawyer. No one wants you to be a lawyer, by the way. We just had a celebration 2 days ago of the opening of a law firm's administrative complex that they're going to put 100 employees here in Tallahassee. So it was a good economic development jobs thing. It's the very first time I've ever seen a celebration for the arrival of a law firm anywhere. So you're going to be expected to act as jurists. That's a very different thing from what you ran when you were elected to office. I'm pretty sure that that wasn't one of the things that you had in mind, but your county attorney is going to tell you about that. The other part of what I was going to say is, what I'm going to tell you is what I would tell my county commissioners, including my newest county commissioner, Marianne Lindley, who's here in the front row, who's taking notes, and this will appear on my evaluation, I'm sure, in September. But your county attorney is going to tell you what your county does with regard to these issues. But they're present in every county. It just depends on how conservative you act with regard to these issues. First, everything that you make a decision about has to come before you. In other words, there's no self-help anymore. Yes, I know you want to talk to your constituents. Yes, I know you want to talk to the developer. Yes, I know you want to talk to the neighbors who are opposing the project. All of that is potentially problematic because you are a jurist. If you picture yourself as a sitting county court judge, and they have a case which comes before them, they are not permitted to take into consideration things they go out. They can't walk the site by themselves. They can't talk to the parties without the other parties being present. And a form of that is now part of your decision-making process for land use issues. Virtually every land use issue. There's only one land use decision-making item that is no longer, that is not quasi-judicial anymore, and that is comprehensive plan amendments. All of you have comp plans, so comp plan amendments will come before you from time to time. Those are still legislative, even the teensiest ones. But everything else is going to be quasi-judicial. And what is it? It's not too difficult except the following. One, it has to be based upon, your decision has to be based upon what is called competent substantial evidence in the record. What does that mean? The stuff you get in your agenda package, the things you hear from staff, and the things you hear at the public meetings, public hearings, or materials which are presented to you at those meetings. That's what you have to base your decision on. One of the other things that you're going to have problems with is what's called ex parte communication. What does that mean? That means off-the-record communication in some form. How will you get that? Most likely phone calls and most likely emails. You'll be barraged with canned emails if there is a controversial project. They'll all look the same, they'll all be signed by a different person, but they'll all have the same content. What's your obligation at that juncture? Your obligation is to put that in the record. Disclose what you heard, disclose what you got. Your county attorney and your county administrator will tell you how that's done. In our county, we request that the materials be sent to the county administrator so they can be included in the agenda package. That way every county commissioner has the same material. That way the applicant and the neighbors know what's in the package and what everybody has gotten. If you don't, and by the way, a lot of these examples, I'm not trying to pick on any particular county or county commissioner today. It just, these things happen. In Gadsden County here, just to our west, a special exception application came through. It complied with all of the requirements of the land use code, but it was opposed by several residents, and the board voted it down. The court here determined that the decision departed from the essential requirements of law and was not based upon the competent substantial evidence rule, and so it was overturned. That's what happens, and it makes it very difficult for your lawyer to defend those sorts of cases when you don't base your decision on the materials in front of you. Here's the town of Longboat Key. They likewise lost a case based upon the competent substantial evidence test. They found that the fact gathering had taken place off-site. $400 million development. The district court found that the circuit court focused with precision on the specific words in the code and that there were no definitions. The court utilized the dictionary, and therefore the town lost. All right, moving on, new topic. Voting issues. You're going to hear from Carrie Stillman, who's the next speaker at 10 o'clock, about a number of things dealing with voting. Voting conflict is going to be your biggest issue. But people have asked me a couple of times, we'll get to that in a second. Unlike if you own stock, and I don't, but people do own stock, you will get from time to time in the mail a proxy card from IBM or Coca-Cola or Walmart or whatever. And now you are on the board of directors of one of the biggest corporations in your jurisdiction, the Board of County Commissioners. It really is like the board of directors of a corporation, but board rules don't apply. You have to vote in person. And the rule in Florida, by the way, a little oddly, is if you're in the legislature, you have to vote even if you have a conflict. The rule for you is different. You are required to vote unless you have a conflict of interest, and then you have to disclose that and file a form. Carrie will talk more about that, and I will here in a second. But the bottom line is you can't absent yourself from a vote, and you can't vote in absentia. Sunshine Law. It's right now one of the bigger issues in the state, so along with public records, and we're going to talk about that here in a second. The Sunshine Law issues, though, are because the courts and, frankly, the Attorney General's office have expanded, significantly expanded, the parameters of what the Sunshine Law applies to. For example, it applied to you the moment the canvassing board determined that you had won the election. You had not been sworn into office yet, but it applied to you. So did public records. And so there are a couple of cases where people have talked, and the courts have found that it applied to the successful candidate as well. So Sunshine Law applies to you now. What is that in general? It means that you cannot have a meeting without the meeting being noticed. How do they define meeting? Pat Gleason this afternoon will tell you that it's two or more individuals from the same entity. Here's the caution. You're going to find yourself on lots of entities other than the Board of County Commissioners. You're going to find yourself on your Metropolitan Planning Organization. You're going to find yourself on some joint task force with maybe a municipality in your jurisdiction. You're going to find yourself on some sort of subcommittees that are established where you and another commissioner are on that board. All of those instances could give rise to a problem with Sunshine Law. And how do you fix that? You notice the meeting and you take minutes. That's it. The fix is easy. Recognition of the issue is the problem, but the fix is easy. You run an ad and someone takes minutes. Minutes are just are really a small version of what took place. It's not a transcript. Some people believe they have to be recorded. The answer is no. It's good to record them so that you can save it for posterity, but under 286.011, the only thing which is required of you is notice and minutes. Now, there is a potential problem with that. Just keep an eye on, and obviously your lawyer will tell you, there are a couple of bills that are making their way through the legislature as we speak on the right to speak at public meetings. I don't know how those are going to turn out at the very end. You may recall, or maybe you know, that there were 2 court cases that came out in the last couple of years, essentially involving workshops when those local governments said to citizens in the audience, you have the right to be here, but you don't have the right to speak. And the legislature is about to, I believe, adopt legislation which changes that and mandates that you have an opportunity to speak somewhere along the line. I have a very pro-local government bias. I have a very pro-home rule bias. Therefore, I think this legislation by the legislature sucks. Why? Because they're not making it apply to themselves. If you've ever gone to a committee hearing and the chair of the committee says, well, we ain't taking any speakers today, after you've gone there and filled out the card and prepared your materials and all of those sorts of things, all of these bills do not apply to the legislature. And so they're making sure that they're fixing something that doesn't really need fixing. That's why I wanted to toss in my prejudice there in advance so that you knew where I was coming from. But keep an eye out for that. It may affect the third mandatory thing that you have to do at a sunshine law triggered meeting, which is allow people to speak. What not to do? All right. The 2 commissioners in the city of Lake Wales did 2 things wrong. The women in the room may or may not know this, but the men do. Rule 1, there's no talking in the men's room, okay? That's just a rule. It's been a rule since I was 5, all right? When you go to do your business in the men's room, there ain't no talking, okay? There's no whistling, there's no looking, there's no talking, okay? So they already violated one of the main rules of humanity. Item 2, there's no talk. If you are going to talk, don't talk about business. Don't talk about commission business in the restroom. And in this case, 2 city commissioners went into the men's room, and a reporter walked in on them while they were discussing purchasing a piece of property at the gateway to the city. Surprise, the reporter confronted them with that, and they were determined to have violated the Sunshine Law. So if you remember Rule 1, you won't have to remember Rule 2. And so, again, both of these commissioners were charged with Sunshine Law violations. In Lake Wales, the Housing Authority Board, this is a good one, I like this. Mr. Young stood up and said, listen everybody, all of this public discussion is getting on our nerves. Let's go outside and talk about this privately. All right, so you announce that at a public meeting. Surprise, they was found to have violated the Sunshine Law when 2 of his fellow authority members took him up on the offer to go outside and talk about the stuff privately. I suspect that the lawyer for the Lake Wales Housing Authority had some sort of cardiac issue when he announced that. But in any event, it happens. And finally, this can happen. Former president of the Senate, former chair of the Escambia County Commission, and now former inmate, Mr. Childers, he had 2 things wrong with his life, one of which is he was accused of and convicted of taking a bribe, and that's all. we'll talk about that here in a second under the honest services issue. But item 2 is he also discussed the matter in private with other commissioners. This was the acquisition of a piece of property. If anybody's from Escambia or in the area, you may recall that one of his accusers, a fellow commissioner, died right during the pendency of the trial under what I would guess people would call suspicious circumstances. Not too many people drink antifreeze under the porch of their house. And so that has been, by the way, Mr. Childers' argument in court that he was denied his due process in the criminal case, not the Sunshine Law case, because he was unable to confront his accuser because the accuser was deceased. By the way, the 11th Circuit Court of Appeals in Atlanta has not bought that argument so far and has reinstated his bribery conviction. In this case, I have this article in my desk drawer. I have not had to use it in quite some time and don't plan on ever using it again, but the article from his sentencing hearing from the Pensacola News Journal, maybe, has a quote from the trial judge, and the trial judge said, "Mr. Childers, I'm sentencing you to the fullest amount of time in jail, 60 days, and $500 in fine, because you failed to follow the advice of your county attorney." So that part I have highlighted and put in my desk as just a sort of a reminder to folks who might come on by. All right. There are 2, and really only 2, exceptions to meetings which are held that are not subject to Sunshine Law in general. One is if you have a bargaining unit, a union in your county, then your preparation for collective bargaining, contract negotiations, and your meeting with your lawyer and your administrator, those discussions can take place behind closed doors because that exception exists in Chapter 447, which is the collective bargaining statutes in Florida. The other exception, which is 286.0118, is an add-on that happened in the 1980s, so it was quite some time before this was actually accepted, and that is what is called, sometimes they're called closed-door meetings, sometimes they're called attorney-client meetings, sometimes they're called shade meetings, but in essence, this exception is only available to you if you are in litigation, not threatened litigation, not a claim, but an actual lawsuit is pending against your county, and your lawyer says, I need to get your direction or advice on the case, usually settlement. Do you want to propose one, or we've received a settlement proposal and we should discuss it. The closed door aspect is so your lawyer can give you the merits of your case and it's not disclosed publicly. You have to do that in a special way. You have to open the meeting publicly, then go to the closed door meeting. You have to have a court reporter who transcribes it. Then you come back to the open meeting and finish your meeting. That transcription has to be done, and it's exempt from public records until the case is over. And I saw somebody's hand in the back of the room. Yes, sir.
Is that optional for you elected the board to, even though it has the wider privy to that protection, to not have it all be open?
I don't know if you heard the question is, could you decide not to have a closed door meeting? The answer is absolutely. That's purely, you're the client, it's your option. If you know, there are pros and cons of that, which I'm sure your lawyer will tell you, one of which is a fiduciary issue, which you ought to give some thought to, which is if you disclose the bad parts of your case publicly causing you to lose, was that somehow a fiduciary obligation that you breached? That is for you and your lawyer to determine. But so it's really important that the technical part of this is very important to follow, because if you don't follow it precisely, it's deemed to be a sunshine law violation. There are a half a dozen or more cases, old cases out there. By the way, the only people in the room are the commissioners, the lawyers, and I say lawyers because your county attorney, and if you have special counsel, can all be in attendance, and your county administrator, not your assistant county administrator, not your county engineer, not your clerk. None of those individuals are allowed in. And a violation occurred in Duval County some years ago in which they brought the expert witness into the room to explain to the commissioners why they ought to settle or not settle the case. That's not one of the listed persons, and that was deemed to be a sunshine law violation. The court did not punish the commissioners, but punished the county by ordering that the transcript of the hearing be given to the plaintiff's lawyer. Surprise, the case settled in about 3 days. Here's the city of Vernon, just as an example. They failed to follow those technical requirements, and two things happened. Technical requirements are they opened the meeting publicly, they went into private session, then they all left. All right, you have to go back into public session and finish the meeting there. They didn't do that. A newspaper requested, therefore, a copy of the transcript. When they said no, they sued them, and the court said, you violated the law. That was a sunshine law violation. Therefore, the transcript is public, and you have to give it to them. And they also awarded about $4,000 in attorney's fees. All right, conflicts of interest. By the way, you all are very honest, nice people. Don't presume anything I'm telling you is anything to the contrary. This is to try to keep you out of the newspaper unless you want to be. I have said to commissioners before, I don't ever want my picture in the paper unless I'm holding the big check that says Powerball winner on it. You know, after that, I'm just peachy with not having my name or photo in the paper. You should have your name in the paper cutting a ribbon at the new library. But going to jail is not a good photo to have in the newspaper, and this is part of my job here is to try to make sure that you don't. Conflicts of interest. The Florida Ethics Code is Chapter 112. It applies to you. Applies to municipal officials as well. It applies to elected. It applies to appointed officials like me. So that is the source of all of these things. When Carrie talks here at 10 o'clock, I'm sure she will cover both of these issues, but there are two things that you are generally prohibited from doing. You can't do business with your agency. In other words, you can't, if you used to sell books to the county, you can't do that anymore. And you can't have a conflicting employment relationship with the county either. Plus, you're not allowed to have some relationship that is benefited by your office. In other words, you're not allowed to have a conflict in your job duties as a commissioner, especially with voting. The cases, or there's lots of cases at the Ethics Commission on voting conflict issues. Some are not. The best thing in the world for you to do, and again, I'll say this a couple more times, is talk to your county attorney in advance about whether or not they believe that you have a voting conflict before you vote on something. Is that conversation with your lawyer confidential? Yes. If he tells you you don't have a conflict, is that binding on the Ethics Commission? No. It's just good advice. And I have been under the impression that the Ethics Commission has gone much, much lighter on folks who have followed the advice of their counsel than have not. So it may not save you from a violation, but it might very well save you from the penalty for having done so. This gentleman here from Bunnell ended up having to pay $2,500 for a violation. He had a towing business and contracted with the city to do all of their towing services. Okay, surprise, that's not allowed under Chapter 112. All right, you do it anyhow. You get yourself in a pickle, you get yourself an ethics charge, or you get sued in some fashion. Under Chapter 111, counties are authorized, and I believe are obligated, to provide you a defense. The defense happens in different ways, though. In most instances, if it's an ethics violation, virtually every county here in the state requires that you hire your own lawyer. Some counties, and that again is a question to ask your lawyer, will represent you through the county attorney's office up to the point that the Ethics Commission makes a determination that there is probable cause to believe that you violated Chapter 112, then they step out, because now you have crossed the line and you've done something that is not part of your job duties. But the silver lining of all of this is, if you did nothing wrong, you were entitled to be reimbursed for all of your costs and out-of-pockets and attorney's fees. For those of you in the general area here, you may have seen that last week Mayor Marks, who had an ethics charge, serious ethics charge against him, was found not to have violated the ethics code, and the City Commission voted to reimburse him his attorney's fees, which were, help me here, about $86,000. He hired Barry Richards. I don't know if you know who that person is. He charges $700 an hour. There's lots of other lawyers. I like Barry, but $700, come on. Anyhow, but he gave a reduced rate, and so we have in Leon County, okay, I have significant lawyers that we hire as special counsel from time to time who are very, very good at what they do, who charge me $200 an hour. And so we have, and you might want to look, a policy. If you don't have a policy, I highly recommend that you get one and establish one in advance. We did not some years ago, and it was very embarrassing for me and for the commission that we didn't have a policy in place about how we process this request. And fortunately, the request then was a very small amount of money, about $1,200. But our policy says, how do you process it? What are the rules? And if you win, how much do you get reimbursed? We cap our reimbursement at $225 an hour. So you can hire anyone you want. You can hire Barry at $700 an hour. You can hire the guy, what's the guy's name, Spence, the guy that has the fringe on the jackets from Montana, at $800 an hour. Anybody you want, but you're only going to be reimbursed $225 an hour for a reasonable time, and that's up to my office to determine. Yes, sir.
Is there any provision in statute that we send the ethics complaints? You have to go through the expenditure method. Any way held accountable, you can go back and stop something?
In the Florida statutes, there is a statute that's called 57.105. That's the meritless case statute. If someone sues you and there's no merit to their claim, you can seek attorney's fees and costs under 57.105 The courts are familiar with that statute. It is used with some frequency, and so that's available. There is an equivalent in Chapter 112 for the Ethics Commission. It is used almost never by the people who are exonerated because the Ethics Commission has just in the past been very reluctant to award fees and costs against someone. They've done it, but it's rare. Way more rare than the court system has done that. So yes, the answer to your question is yes, that's available, but it's very infrequent that the Ethics Commission does that. And you may have read one of the problems with the Ethics Commission right now is they can't collect the stuff. I mean, they can award the fines, but they're having a very difficult time collecting it. And so, but under 57105, if you got sued in circuit court and you or your county or both win, then I'm going to file a motion for fees and costs against the other side. And one of the changes in that statute in the last few years is the lawyer on the other side has to pay half. That's a pretty good rule to keep unscrupulous lawyers, and no comment on lawyers because my dad's proud of me, but there's a lot of unscrupulous lawyers out there. And so, but it's out, it exists. I would do it if I had a charge filed against me. And speaking of charges against the county, these are two cases with which I have some significant familiarity because they both involved a former president of the Florida Association of Counties and former chair of the Board of County Commissioners and former Commissioner Rudy Malloy. These are up here to tell you there are two kinds of cases that involve reimbursement of fees. One is for civil matters, including ethics, and there are also support in the Florida cases for criminal matters. Those of you who have been around a while, we'll call you veterans, may remember a guy by the name of John Lamello, mayor of Sunrise, did a lot of stuff while he was mayor of Sunrise. But in one of the cases, he was found not guilty. That case went to the Supreme Court, and the court said, no, even in criminal cases, you're entitled to be reimbursed for your fees. So bring out these two cases. In this case, a commissioner was accused of sexual harassment for having had sex with his commission aides, plural, 4 of them. Sequentially. And while that was being investigated by the governor's office ordered FDLE to investigate that. While that was being investigated, they also discovered certain reimbursement requests that he had submitted that indicated that he had double dipped in that. So I say all that by saying he was found not guilty of all of those things. He was found not to have committed an ethics violation for the activities with his commission aides, and that's the Malloy versus Board of County Commissioners case, in which case, by the way, the Board of County Commissioners declined to pay his fees. It went up on appeal to the First District. The First District, bless you, said, yes, you have to pay those fees. It was about $235,000. Then on the remand on this case, now this is, I'm making light of this because it was kind of interesting at the time. On remand, the court said, oops, sorry, you may have won the ethics case, but you did not meet the test. There is a test out of Fort Walton. It's called the Thornburr test. That's the name of a case. The Thornburr test says you're entitled to reimbursement of your fees if you meet this 2-part test. One, the conduct that you were engaged in had to be a part of your job duties as an elected or appointed official. And part two, it had to have served a public purpose. And we hereby find that having sex with your aide did not serve a public purpose. It may have served some other sort of a purpose, but it did not serve a public purpose. And so we won that case and did not have to pay him the $235,000. On the other hand, he was successful in defending himself against the double dipping charges, and we did have to pay those fees for the criminal case, which were, by the way, about another $200,000. Yes, sir.
Sexual abuse or spending money?
He was, at the time he was a commissioner, also employed by a state agency and went on trips for both, but ultimately a jury found him to be not guilty. And so 4 misdemeanor charges. If you went to a lawyer here in town and said, I have 4 misdemeanor charges against me, they charge about $1,000. This cost us about $250,000. I want to make sure I'm on time here. So, anybody from Orange County in the room? Good, we can talk about them then. A good thing. They are engaged right now in a huge lawsuit, and so I'm not going to say something which would prejudice that, but let me just tell you about how the public records law and electronic communications have not kind of merged yet. Easy ones. Every letter you get at your office, at the county commission offices, that is addressed to you as a county commissioner is a public record. You have to save it for a period of time, usually 7 years, and you have to produce it if it's requested. That same rule applies to email that you get. So as if it was a letter that came with a postage stamp, the same rule applies to email which you receive on your county computer from anybody related to county business addressed to you.
We have to save it, or they have to save it all?
It has to be saved is the answer to that. And everybody does it differently. Some county commissioners I know save their emails on their own PC. Some people have a server that it is sent to where it is saved. Some people copy another email site where it is saved. But as long as it is saved and it is able to be retrieved, then you've done what you're supposed to do. Some people print them all and put them in files. I mean, any way is fine. But emails that you receive are the same as letters that you receive. Okay, so here's something different about that. Emails that you receive on your home computer are the same. If they're about county business or they're directed to you as a county commissioner, they're public records and have to be saved the same as if you got them at your office. Does that make your home computer a public computer? No, just those items which you receive. The flip side of that comes out of the city of Clearwater. The city of Clearwater case involved a request for emails that were personal in nature, and the city of Clearwater said, no, we're not giving them to you. It could be anything. It could be from your spouse. It could pick up bread and milk on the way home. They could be jokes, which I highly recommend you not do, but whatever. But personal emails about meeting me for lunch or picking up bread and milk, or your investments that you're making are going south and you get that from your broker. I mean, any of those sorts of things, those are not public records, even if you got them on your public computer. Here's the problem for Orange County. Texts. Text messages that are about your county business are public records. I don't think there's ever going to be anybody who says that they're not. The problem with text messages is it's very difficult to save them, and it's very difficult to retrieve them. Be very cautious. That's what this case is about in Orange County. There was a push by employee unions to request that the Orange County Commission put a referendum on the ballot that mandated that private employers give sick time, basically Disney employees, by the way. And there was a huge battle over that, and the lobbyists on behalf of those employees were texting the commissioners during a commission meeting. And then there was a request for those text messages, and it has become a real problem for them. What do I recommend? If you have a methodology to save your text messages that are county business, then do that. If you don't text. Okay? Don't text while driving, and don't text while county commissioning. That will save you a lot of grief and aggravation. We have turned the text function off on all of our county-issued cell phones just to avoid that issue. That's pretty severe, but it saves us a lot of aggravation. Those who have private cell phones themselves, we have requested that they not text public information. Honest services and bribery is the last section to hit on real fast. I think I got about, what, 5 minutes, 3 minutes? I said this at the, and some of you have heard a lot of this probably if you went to the Gainesville workshop. You've heard this statement from me before, but I'm going to say it again because it's worth saying. When you got elected to office as a county commissioner, you gained no new friends. Keep that in mind, okay? People who are saying, wow, you're the best friend I've ever had in all the world. Okay, they're A, lying, and B, want something from you. And the only difference between that and this is how badly they want it from you. Temptation is a very bad thing. It has gone on for millennia. But it still exists. Just to give you an example of a bribery issue, there was an article in the newspaper online edition yesterday out of New York, you may have read. A New York senator was arrested for having tried to bribe the Republican Party into deeming him to be a Republican when he was not, so he could get on the ballot to run against Bloomberg in the mayoral election coming up. Okay? I don't know what party affiliation you may be, but that's the first time I've ever heard of anybody wanting to be bribed to be a Republican. In the Senate and House here, maybe. But that's the first I've ever heard of someone wanting to do that to change their party affiliation. You can do that right at the supervisor of elections office this afternoon if that's really important to you. Okay. Honest services, let me talk about that very quickly. For the last 10 years, this piece of federal legislation out of Title 18 was the most significantly used criminal matter in Florida and around the country. It essentially is the old, I'd like to sell you some swampland in Florida mail from the 1920s, converted over the years into a process by which if you deprive someone of your right to honest services, that was a criminal charge. The Justice Department and the FBI still use this. It has become lesser in the last couple of years because there's the two county commissioners. By the way, at one point 4 years ago, the Palm Beach County Commission had a quorum in federal prison. Okay, that's not a good thing. and it was everywhere. Who had the most elected officials convicted of bribery or honest services violation in the last 10 years? What state? Yeah, that ain't really the reputation we want to have. No, not New Jersey, not New York, not California. Okay, who had the least, by the way? Wild guess. Nebraska. No one wants to go to Nebraska, I guess. You may remember a little bit about the Enron case. This guy, Jeffrey Skilling, he scammed a lot of people. Quick facts, he cooked the books to make Enron look like they were worth a lot more money than they actually were. Therefore, the price of their stock went way up. He exercised a pile of stock options. He then sold all his stock. Then he told everybody that the books were a lie. But he had already made the money. He was arrested by the FBI and ultimately charged with multiple counts of honest services. This case went to the U.S. Supreme Court, though, and the U.S. Supreme Court said self-dealing, which is what this was, is not an honest services violation, at least henceforth. But bribery and kickbacks are. So that's still out there for that aspect. The FBI is still around working on these cases. And so be very careful. Why would they use the federal statute? I mean, bribery is a violation of law here. It's a felony. In the honest services case, each count of an honest services violation is 20 years in federal prison. Plus, you lose your FRS pension, you lose your private pension, you lose anything you gained with the money you acquired from that. And depending upon your age, you will either die in federal prison or come out penniless. It's really not a good thing. And that's really how the FBI got most of the folks to plead to much lesser amounts of time, 4, 5, 6 years, because that's how they bargained. They said, you have 10 counts, that's 200 years in federal prison, you're going to die there. Or you can cop a plea to 4. I'm taking 4 every time on a deal like that. That's just this is all in your, there's 1,762 individuals in Florida. That's 50 convictions of elected officials a year. That's pretty embarrassing. There are a bunch of ethics reforms currently pending. Hit on Carrie to tell you about them because I support at least parts of most of them anyhow. And mostly to try to give the Ethics Commission some additional powers. And so it's Senate Bill 2 and 4 just to keep your eye on. That ad appears every Sunday in the Jacksonville Times-Union and other newspapers around the state. The FBI is still on this stuff. They still have open, active investigations in at least 3 counties that I know of. And try to avoid anything that even smells like you're doing something that looks like bad conduct like we're talking about. None of you, absolutely none, will ever be convicted of honest services fraud because you heard this presentation today. So I'm pretty convinced of that. Yes, sir.
On the earlier examples you gave on Sunshine Valley, particularly the restroom discussion, if they would have turned around and walked back into the meeting and declared in the open meeting ex parte communication, would that still have been allowed to be filed?
There are cures to sunshine law violations where there is an open discussion of the matter subsequently. Whether that would have cured this one, I don't know. But there have been cures. Basically, the court has said, to the extent that it looks like you didn't have a preconceived decision made, that you had an open and frank discussion afterwards, that might save you.
I mean, I could see walking in there and one guy turns to the other and says, boy, this discussion we're having right now is really difficult. I'm having a hard time with it. And the reporter walks in right there and says, oh,
See, what you just described to me, I don't think is a sunshine law violation, because I think you're just saying that this is a long meeting. You walk in there and say, the guy that just testified or got up, he's really a nut. You know, you say, wow.
It's okay to say that, because I do it all the time.
Commissioner Lindley doesn't say that. I say that all the time. That's it from my standpoint. I appreciate it.